Tonight on the Daily Debrief, a deadly shooting of a black teen and questions over the use of language.
The subject lunged at the officers with the knife. Did you write that?
I did.
Prosecutors say it's a cop cover-up. And a second defendant in court to answer for the murder of 8 people in rural Ohio. Plus, someone close to O.J. Simpson claims to have new details about the murder of Lon Goldman and Nicole Brown Simpson. That's straight ahead on the Daily Debrief for Wednesday, November 28th. And good evening, everybody. Welcome to the Daily Debrief, day 2 of testimony in what we are calling the case of an alleged cop cover-up. It all surrounds what happened in this video you're about to watch, which shows Chicago police officer Jason Van Dyke shooting and killing a knife-wielding teenager named Laquan McDonald. McDonald was tried and convicted of murder, Van Dyke was rather, but now 3 other officers are on trial. 3 men are accused of conspiracy, official misconduct, and obstruction of justice. Prosecutors say they lied in their official reports by claiming Laquan McDonald attacked the officer who shot him. Each officer has his own defense. We'll talk about those defenses in a moment, but first let's go straight to testimony. The first witness to take the stand was a record services officer for the Chicago Police Department. He suggested that the defendant's reports were written to make Laquan McDonald look like the aggressor.
McDonald's raised a knife across his chest and over his shoulder, pointing the knife at Van Dyke.
What did Defendant March report next?
Van Dyke believed McDonald was attacking Van Dyke with the knife and attempting to kill Van Dyke.
What did Defendant March report next?
In defense of his life, Van Dyke backpedaled and fired his handgun at McDonald to stop the attack.
What did he report next?
McDonald fell to the ground, but continued to move and continued to grasp the knife, refusing to let it go of it.
What did Defendant March report next?
Van Dyke continued to fire his weapon at McDonald as McDonald was on the ground, as McDonald appeared to be attempting to get up, all the while continuing to point the knife at Van Dyke.
The next witness was an investigator at the medical examiner's office. Here he faces harsh questions about what defendant David March said and what that defendant did not say.
And correct me if I misread this. Upon arrival, beat 815 Robert was confronted by the subject who threatened the officers with a 4-inch fold knife. Did I read that sentence correctly?
Yes.
Are you telling this court that David, strike that Detective March told you it was a 4-inch knife?
Yes.
Now, there are times, are there not, Mr. Briggs, that sometimes you put words in quotations in the narrative section, right?
Yes.
Meaning that when something's in quotations, it's the exact words used by the caller. True?
True.
You wrote, the subject lunged at the officers with the knife. Did you write that?
I did.
And are you telling us that this person who claimed to be Detective March used the word lunged?
Yes.
You did not put the word lunged in quotation marks, did you?
No.
The third witness in this case was a Chicago police sergeant who reviewed the video of the scene and the reports.
Based on what you saw on the video, should a reasonable officer in Walsh's physical position have completed an officer battery report?
Just based on the video, and Officer Walsh didn't use any force that I could see in the video, the answer would be no. It wouldn't have been necessary.
Now, importantly, Sergeant, is assault subjective or objective?
That's objective.
What does that mean?
Well, everything that an officer does is based on the objectively reasonable standard, and that's what we train with our use of force.
Our guest tonight is former federal prosecutor Francey Hakes. Francey, good evening.
Hi, Aaron. How are you?
I'm well. A lot of questions in this case about the use of language here, specifically in the report which says Laquan McDonald lunged at the officers. Questions about who wrote it and why they wrote it.
Well, and you see clearly that Laquan McDonald lunged at nobody. There was a question as to whether he might have turned slightly toward the officers, but the video is very clear. He lunged at no one. And so the question really becomes, did the officer say he lunged at them? Did the medical examiner investigator write it down correctly? Were the officers telling the truth? There are a lot of questions here.
Yeah, and of course, if the officers didn't utter that word and someone else who was filing a report was the one that injected it into the record here, that changes everything in this case.
Well, it does, because if the officers didn't falsely claim that Laquan McDonald lunged at them, then perhaps they're telling the truth about other aspects as well. It helps their credibility.
Yeah, let's go back to the opening statements for some context in this case. Prosecutors there started their case by alleging a dereliction of duty here.
This case is about violating the public trust. The case is clear, the case is straightforward, and it's concise. It boils down to what defendants wrote on paper versus what is shown on video. The evidence will show that Defendant March, Defendant Gaffney, and Defendant Walsh each knowingly filed false police reports, thereby committing the act of official misconduct and obstruction of justice, and that they participated in a conspiracy to commit those same crimes.
Described the shooting from the perspective of an officer who will apparently be the state's star witness. That witness is Officer Dora Fontaine. She's seen here testifying during the original trial against Officer Jason Van Dyke. Prosecutors say she will testify in this case that she saw one thing, but that official reports penned by at least one of the defendants put different words in her mouth.
She could hear drop the knife. She could hear the bullets. She saw him twitching. She saw the smoke come from his body. What she did not know, and will testify
Can you
to,
scroll past this to this?
is that she did not see McDonald attack or attempt to attack anyone before or during the shooting. She did not see him swing the knife in an aggressive, exaggerated manner toward anyone. She did not see him continue to advance toward Van Dyke, nor did she see him raise his arm toward Van Dyke as if attacking Van Dyke. She did not see him raise knife across his chest over his shoulder. She did not see McDonald point the knife at Van Dyke. She did not see him attempt to get up while he was being shot by Van Dyke. She did not see him batter anyone. Yet the evidence will show that official police reports completed by Defendant March and others contain those false statements.
All right, let's bring Francey Hakes back into the conversation here. Francey, a lot of the trouble here surrounds the two incidents. One was with the first responding officers. The second was with the deadly shooting. Is it accurate to say here that the trouble is that at least one of the defendants, possibly all of the defendants, conflated the two incidents and put everything into one report together?
Well, I imagine that's what the defense will claim, that their quote-unquote false statements were just mistaken, that they weren't false or at least weren't purposefully false. But police officers are trained to be trained observers and to understand different incidences and put them in context. And I would be surprised if that actually happened on a scale more than one officer. I mean, I think it would be unusual if you've got multiple officers making the exact same mistake in their reports. That doesn't make any sense to me.
You know, questions as to whether or not that's proof of collusion or whatnot, because, again, we're back to this word lunge. That seems to be the fatal error here for a lot of people. And one of the defenses is that, well, we're talking about one word in 50 pages of reports.
Except that we're talking about more than that, aren't we, Aaron? We're talking about police officers who shot a man and the appearance of which on video looks pretty indefensible. When you combine that with reports that look purposefully wrong, then it does start to smell like a conspiracy.
All right, we're going to talk about the defenses in this cop cover-up case after the break. But first, a new theory in the O.J. Simpson murder case, plus an arraignment in the so-called Pike County murders, which left 8 people dead in rural Ohio. Part 2 of the debrief is after the break. O.J. Simpson's former manager claims he has bombshell information about the football star's infamous murder case. Norman Pardo managed Simpson for 20 years. He now says in a soon-to-be-released documentary that the Juice is not only directly involved in Nicole Brown Simpson and Ron Goldman's deaths, but that Simpson did not act alone. Pardo promises his documentary will be the most thorough investigation into the murder and will include more than 70 hours of never-before-seen video of Simpson. An arraignment today in the case of the so-called Pike County murders in Ohio. 8 members of the Roden family were killed in their homes. George Wagner IV was arraigned today on a 22-count indictment, which includes murder charges carrying a possible death sentence. Wagner is one of 4 people facing the same or similar charges of the case. An assistant Ohio attorney general today said the motive involved a child custody matter and that this defendant is the worst of the batch.
He broke into 4 separate residents on one night and did participate in the killing of 8 different individuals, most of whom lay sleeping in their beds. We did provide the court with information that we have through confidential reliable source that there was discussions amongst these 4 co-defendants, specifically Jacob, George, Billy, and Angela, that if one or more of them were arrested and one of them remained at large, that person should take revenge on anybody who went against them, and they specifically also named Special Agent Scheider, Sheriff Reeder, and Mike DeWine, and or help the other individuals escape. And I would note that was not the only conversation. I only brought up that conversation because it pertained to Ms. Wagner, but there have been multiple conversations where those sorts of threats have been made, and I would say that specifically George Wagner was probably the most vocal in making those threats.
As you heard, the prosecutor said the defendants discussed making threats against the local sheriff, the state attorney general, and others, or to help one another escape. The judge refused to grant bail in this case. Wagner pleaded not guilty to the charges. Let's pause for a check of other newsworthy criminal cases with Anthony Velez.
Here are today's top crime stories trending on Law&Crime.com and across the country. A woman in Kansas pleaded guilty to murder and child abuse charges in connection to the killing of her 3-year-old son, whose body was discovered buried in concrete in her Wichita home. 37-year-old Miranda Miller pleaded guilty to multiple charges, including second-degree murder, for her role in the death of her son, Evan, who reportedly died after months of being tortured by Miller and her boyfriend, 41-year-old Stephen Bodine. In exchange for a lower charge, Miller testified against Bodine at trial, stating he killed Evan. Bodine was convicted of first-degree murder and faces a possible life sentence. Miller now faces 29 years in prison. A woman in Maryland accused of smothering an infant girl to death confessed in court that she killed the baby because she wouldn't go to sleep. 24-year-old Leah Walden reportedly admitted she intentionally killed the infant, 8-month-old Reese Bowman, during a hearing at the Baltimore Circuit Court. Walden allegedly smothered the victim at the Rocket Tears Learning Center in Baltimore and initially reported the death as a sudden, unexplained infant death until authorities checked surveillance footage. Walden pleaded guilty to first-degree murder and will now serve 70 years in prison. A former police chief in Florida was sentenced to 3 years in prison after he admitted to framing innocent black men for a series of unsolved burglaries to polish property crime stats and appease community leaders. Ex-Biscayne Park Police Chief Raimundo Atasanio pleaded guilty earlier this year to directing his officers to frame the innocent men who had prior criminal past of unsolved burglaries and vehicle break-ins. Atasanio pleaded guilty to a conspiracy charge and faced a maximum sentence of 10 years in prison. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Back now to the so-called cop cover-up trial where each defendant's attorney gave an opening statement. The first attacked the prosecutor and the victim.
David March is an innocent man. Not just because he's presumed innocent, it's because he actually is innocent. And what counsel just told you in her opening statement will not be borne out by the evidence. First of all, I don't know why she said it, but counsel interjected in her opening statement the race of Laquan McDonald. Race has nothing to do with this case. This case is about law and order. It's about Laquan McDonald not following any laws that night. There must be some individual responsibility attached to McDonald. Counsel says McDonald committed non-violent crimes. Nothing could be further from the truth. Laquan McDonald is armed with a knife. Under Illinois law, Judge, you're going to find out that knife is a Category 2 dangerous weapon. And with that knife, he is committing forcible felonies. He is burglarizing trucks in a truck yard several blocks away. Now, counsel will say that's a nonviolent crime. Well, maybe, but it is a forcible felony, and that's important. It's important for David March and the complete investigation he did in this case.
That same attorney said his client's reports accurately portrayed what Laquan McDonald did that night, and he called the state's key witness a liar.
Dave March never writes that Jason Van Dyke was battered. Dave March wrote over 50 pages, single space, of reports in this case. One half of one sentence amounts to obstructing justice and official misconduct? You got to be kidding me. What she's coming off of, she said. She said it. And the only reason she's coming off of it now is she has to be a witness in this case because she needs this job. Because like Joe Walsh and Tom Gaffney and so many other 8th District police officers that night, the Inspector General wanted her fired too.
The defense for the next officer said the whole issue in this case is that his client perceived the shooting differently from what the video shows.
And the theory is, as I understand it correctly, is that a video contradicts what a human being's perception was of events on October 20th, 2014. And it's absolutely fundamental to our system of justice that human beings, based upon who we are, perceive things differently. On October 20th of 2014, Joe Walsh was a 16-year patrolman in the 8th District. He was assigned a partner. His partner was Jason Van Dyke. That would be the second time in his entire career that he had been ever assigned for Jason Van Dyke to be his partner. And I bring that up to you, Judge, because in the indictment in this case, it is alleged, and you have heard a presentation, that somehow Joe Walsh began on the evening of October 20th to engage in and to agree to be a member of a conspiracy to help an individual who had only been his partner one time before.
The defense for the third officer said the only reason his client was on trial was because prosecutors disagreed with his written report.
Judge, what is Tom Gaffney doing here?
Because they disagreed with the report that he wrote, he must have attached himself to some type of conspiracy to obstruct justice, some type of conspiracy to prevent independent criminal investigators of finding the real truth of what happened to Laquan McDonald during the shooting. The evidence will show, Judge, that that theory is complete and utter nonsense. What the state doesn't have, and what they didn't tell you, Judge, is they don't have a lick of evidence that there was any type of conspiracy here. They don't have a shred of evidence that Tom Gaffney agreed to obstruct what really happened to Laquan McDonald during the course of the shooting. In fact, Judge, the evidence is going to show just the opposite.
Tom Gaffney was not a witness to the shooting. He didn't see what happened during the shooting. He never said he saw what happened during the shooting. How the heck could he ever be part of an agreement to conceal the real facts of what happened during that shooting that he never saw?
That same attorney said part of the issue was that his client had a violent run-in with Laquan McDonald earlier that night.
Laquan McDonald is now on the passenger side of his squad car, facing him, eye to eye. He raises the knife. State forgot to tell you about this part. Raises his knife, looking right at my client who's in the driver's seat, and smashes the knife on the windshield. As a result of this encounter that my client had with Laquan McDonald, there's certain reports he had to generate. He has to fill out an officer battery report. Now, a lot's been made about, well, he wasn't battered. Why is he doing an officer battery report? This is the form that back in 2014 the department used. It wasn't just for officers who were battered. It's called an officer battery report, but it includes and it requires officers to fill that report out when you were assaulted. And make no mistake about it, Your Honor, the evidence is going to show Laquan McDonald faced him right in the eye, raised that knife, and when he raised that knife at my client, Tom Gaffney, he readied himself. He readied himself to use lethal force. And he made a split-second decision not to use force.
Back to Francey Hakes one last time here tonight in the minute we have left. Francey, these defenses involve conflating a couple of incidents, poor perceptions, and blaming the victim. What's your analysis?
Well, specifically with the third defense attorney, Gaffney's attorney, I think it's really interesting because he says that he couldn't have been engaged in some conspiracy to lie about what really happened. Really, he was just mistaken with an earlier battery or an earlier assault that he received when Laquan McDonald faced him down with a knife raised. But that really doesn't compute with me, Aaron, because you simply cannot confuse that incident with the shooting by a whole different officer in a different location. So I think they're going to have a really tough road with this judge, and they've obviously picked a bench trial instead of a jury trial. I think that's for a good reason.
Yeah, hopefully the judge will really look into this and, of course, arrive at a just verdict. Francey, appreciate your insight as always here on The Debrief.
Happy to be with you, Aaron. Thanks.
All right, we'll see you next time. And that's all the time we have for today on The Daily Debrief. Our live coverage of cases around the country resumes tomorrow at 9 o'clock Eastern. And, of course, I'll be here on The Debrief from 5 to 5:30. From all of us at Law&Crime, have a good evening. We'll see you back here tomorrow.